My name is Stephen G. Cobb. I've been practicing criminal defense law since July the 2nd of 1990, certified as a specialist in the field since 2002, and I'm your host of Florida Criminal Law TV. As you can see, it's Casual Friday, meaning no court, and I get to answer your questions about criminal law. Now, this next question is really pertinent because just yesterday, I was asked this question not once, but twice. And this is what the question is. I'm on felony probation. Can my probation officer violate me for not having everything done if I still have a little under 2 months before probation ends? Well, this is a felony probation question. Someone was placed on probation in felony court. Now, I'm also going to cover misdemeanor because I got that question in a misdemeanor case yesterday. But in the felony context, you have to look at the written plea agreement. Back in the day when I first started practicing criminal defense law in my hometown of Pensacola, Florida, I went to violation of probation hearings and took a look at all these cases, and they were terrible. And I tried to enter admissions of violation with no major harm to my client, and this judge pounded every single one of my clients with massive amounts of jail time, and nothing I said worked. And I thought to myself after court, this is never happening again. So what I did was I hit the books. I mean, this is a pre-internet era. So I hit the books with a vengeance. I began filing oral and written motions to strike the counts of the affidavit of violation and dismiss the counts for violation. And, you know, after being in court for many, many hours litigating every single case, we started to get some traction, and this particular judge started sentencing more reasonably. Now, what's critical with this question is in the felony context, the written plea agreements were modified after I started getting cases kicked for violating the statute of limitations. So now if you read a felony plea agreement in just about any part of Florida, what you're going to find is it's going to have language that says this: all terms and conditions must be completed 60 days prior to termination of probation. So what happens is people will go through probation, and sometimes they'll get it in their head, I'm just going to wait until I save up enough money and pay all my court costs just before it ends. Well, I've got plenty of time on getting this community service or whatever it is done, and the next thing you know, they find out they've got a warrant. Or worse, they go to visit their probation officer and they're arrested. And then they're going, but I still have almost 2 months. It's too late. Now, what we've done in some cases, and what I'm going to be doing in a couple of cases I recently picked up, is my clients had done all of the requirements, but the information didn't get where it needed to go. So in fact, these people had actually complied with probation, yet due to the fact that they were being supervised in another location, documents didn't go where they were supposed to, that they found themselves in violation, both of them. Now, in the misdemeanor case, it's a little different because misdemeanor plea forms do not contain language that says what most probation officers do is that 30 days before the end of probation, they're going to go through a probationer's file. Anytime they've been 5 minutes late for an appointment, anytime they're $5 short on cost of supervision, or if they're waiting to finish that community service work, the next Saturday, probation officer's not going to wait because they're afraid of a motion to strike and dismiss for a violation of the time frame. They have to have what's called the revocation process set in motion prior to the expiration of probation. In the old days, when I first started practicing, I would find case after case after case where they would give the person till the last minute. They would prepare the affidavit of violation on the last day. They'd run it by their supervisor the next day. Then they would forward it to the judge. The judge would issue an arrest warrant with or without a bond, usually back then with no bond. And then I get this file, and I'm looking at this file. I'm going, wait a minute, that's late. There's no jurisdiction. And so we would kill that probation violation case. So your best practice, and this is what I tell everybody, if I'm representing someone And, whether it's with a team or without a full, proper co-counsel team, I very rarely do that, but occasionally I do. I always caution people, and I would give you this caution, get everything done early. Don't wait until the last minute. If you've got 3 years of felony probation, get everything done in 2. Because here's another little wrinkle. In most counties, if you're given, say, 3 years of probation, some will allow termination at the 50% mark. Others will want 2/3. But in either case, most will grant a motion to terminate early, most judges, at the 2/3 point if you have completed everything. Now, this will save you $40 to $60 in a cost of supervision, depending upon what part of Florida you're in. In some parts of Florida, your monthly probation fee for the cost and luxury of being on probation, the supervision fee is $40 a month plus a 4% surcharge. In other counties, it's $50 a month plus a 4% surcharge, which, it makes it $52. So basically, it'll save you money. It'll save you risk. Get everything done on probation early, and then you want to be talking to your legal team about a motion for early termination of probation instead of asking a question, how can they violate me when I've still got 2 months to go?